Secrets from the defense for you, the law enforcement professional. We got one of the best in the biz. You don't want to miss this. Court's in session. You're on the stand with me, Brian Lass. Let's do this. So what if you could peer into the mind of one of the greatest defense practitioners of our time, not only for the benefit of you as an enforcement or investigative professional in court giving testimony, but everything leading up to court for that matter? Well, that's exactly what we're doing here today. Joining me today is a man who truly is synonymous with the defense practice here in Ontario and abroad. A man who truly is infamous as he is famous. Joining me today, the one and only Frank Alfano.
Good to see you,
Frank, thank you so very kindly for being here today. So, you know, it really goes without saying that you really are the guy as far as the true cliche sense of the term. You'd be hard-pressed to talk to anyone in the legal profession who's not heard of you. But that being said, there's obviously people watching all over the globe. So maybe as a starting point, you could kind of oblige us, give us an idea for those who are not necessarily familiar with the entity that is Frank Alfano.
Well, I've been doing this job. Next month will be 30 years, so I've been doing this job longer than I've not been doing this job. That's all I've ever done, other than play drums, which lasted for a short period of time. But so I spend my days. Courtroom's a playground for me, and every day I defend someone different.
Absolutely. And conversely, on the topic of drums, not to derail the interview, but as well as sharing a love, obviously, for legal advocacy. My former drum teacher, your former drum teacher as well, the great Randy Cook, who's a beast, living in LA, living it up right now. But yeah, so you can YouTube him maybe after this if you're into music. But nevertheless, so Frank, maybe if I could sort of get the ball rolling here, just to open the conversation. I mean, obviously, you've been doing this a very long time. You've had countless enforcement or investigative personnel on the witness stand, the subject of your cross-examination. So, I guess maybe my first question, what a lot of people are maybe wondering for that matter, have you taken note to any sort of, reoccurring theme or definitive area of reoccurring oversight or area of improvement, not only by the officer, number one, in court on the stand giving testimony, presenting their evidence, but as well, everything leading up to court for that matter, for example, all the elements that would compose a disclosure package for that example?
There's a couple themes we see over and over, and we see them in cycles as they come. A newbie officer, for instance, doesn't always consider, what his reasonable suspicion is, what his reasonable probable grounds are, or turn his mind to reasonable prospect of conviction later, right? So one of the things I would say is those who've been doing it a while and think about these things before they start the investigation are in a much better position gathering evidence to make the prosecutor's job easier. And we see that over and over where if any advice I could give to a new officer is build your case right from the start, because with the right foundation, the house won't fall. Absolutely.
And it's funny you mention that, because admittedly, and for those watching who know a little about me, have seen my videos, have seen my articles in Blue Line magazine and all the like, I'm a huge proponent of the idea of thinking about tomorrow, today, so to speak. So right from sort of the the beginning stages of an investigation for that matter. So I guess obviously there's certain things that the officer is going to have to hit in court as part of their testimony. I mean, obviously the essential elements of the actual offense itself, things like jurisdiction, identification. So what's your experience sort of been with that?
There's often a blurry line between what you know and what you can prove. And a lot of times an officer might be told something or know something, but when it comes to court, he might be missing a witness or a document or something that's going to help him prove that case. And one of the things we look for is we look for what's missing and don't tell anybody.
Gotcha. And again, sort of on the same notion, I mean, I can speak firsthand, obviously having this sort of dual skill set, being that a former prosecutor, legal advocate, as well as frontline and enforcement. And, I can speak to scenarios, and unfortunately there are some officers that are of the thought, for example, I can speak to one use of force training scenario I was in. It was an officer, and I forget how the topic came up, but he's of the belief that it's not my job to solve the case, that's the Crown's job. And that being said, I can speak firsthand, with my prosecutorial experience, having a Crown brief, going through it, and literally there's nothing there, and you're wondering almost if the officer is thinking about these, different evidentiary considerations.
Well, the Crown's got to play the hand they're dealt, so if you deal them a bad hand, it's just going to make my job that much easier.
And that goes without saying. And again, obviously, where I like to revert back a lot to is Section 11D of the Charter, the fact that everyone obviously is innocent until proven guilty in court, for lack of a better description. So, and obviously in the law enforcement world, there's a perceivable sort of, excitement of that perceived mountaintop of actually charging someone. But of course, there's very much a world on the other side of that mountaintop, as important, if not more important, than the actual commencing of a proceeding, being the world that I refer to as court process and procedure. So maybe getting back to the actual, evidentiary considerations, so to speak. So, obviously here in Canada, irrespective of all the varying legislation and statutes that we have, there's really 3 different types of offenses. This was set out, of course, in the case RV Sault Ste. Marie. What can you tell us about that in the respective
well, there's essentially 3 classifications of offenses, and generally criminal offenses have something called mens rea, which is a mental element. You have to commit an offense knowing or being negligent as to certain facts. It's basically a mental state. It's an internal element of the offense, right? So if you're going to steal something, I'll give you an example. If I took a stapler and I thought it was mine, that's not really a theft. But if I knew it was yours and I took it with the intention of depriving you forever of it, that would be theft.
Gotcha.
So that's a mental element.
No, of course. And speaking in the provincial, offenses context, obviously, all provincial offenses are assumed to be that of strict liability, and obviously there's a respective threshold, absolute liability. So, a question I have, based on your experience of being in court and obviously, taking witness to the officer's examination in chief, and then obviously having your chance to cross-examine and make the officer shudder on the stand, so to speak. What's your experience, not even necessarily with an officer hitting essential elements, talking about ID, things of this nature, but what I'm curious about is what your experience has been with an officer actually presenting their evidence in a manner that would be indicative of the actual type of offense it is. So, for example, if we're talking about strict liability, obviously the defense has the ability to bring that due diligence offense. So maybe you could just tell us a little about that due diligence offense and what your experience has been.
We call that the spectrum. Because an absolute liability offense, you don't have to prove that the person knew anything or even intended to do it. Just the fact that they did it is sufficient for guilt. And then strict liability is sort of in the middle between mens rea offenses and absolute liability offenses. And a police officer testifying, I found my job was harder when they considered the spectrum or the range. So each classification, if we look at it as a spectrum, anything from speeding, which is absolute liability, to like wheelie stunts where it's mens rea. If they were to testify in a way that gave context and painted a picture that suggested the person knew or should have known, makes my job in cross a lot harder. So one piece of advice I would give is testify according to the spectrum of the charge you're prosecuting.
Gotcha. And again, if any of you watching want to look that case up, it's RV Sault Ste. Marie, like the city, 1979, and that's a case that really sets out that classification of offenses as we speak to today, which, arguably, and again, the subject of one of my prior articles, arguably is one of the more overlooked areas by officers actually frontline in the field.
Sorry to cut you off, but if you want to see an example of this type of problem that Brian is bringing up, I argued a case called Rui Silva, R versus Rui Silva. It was a stunt where the guy did a wheelie and there was no context or no background information, and so that made the prosecutor's job really hard. So that's an example of
the man sets precedents, ladies and gentlemen, right here. The man sets precedent. So maybe what we can do now, obviously there's a lot of officers watching from really over the globe. Maybe we can get sort of into the nitty-gritty of actually evidentiary considerations and what can maybe, further than what we've even talked about, help the officer along. So, obviously as a defense, we in the enforcement world, or even prosecutor, like to say defense playing their defense game, but obviously that's your job. There's a lot of skills and tactics and techniques and things that you'll look at to try to create that reasonable doubt, or maybe even get the sort of the plug pulled on the matter before it sees the lights of day. So one of the areas that I'd like to talk about for a moment here that I've sort of taken notice to is the area of inconsistencies in evidence. And what I mean by that, Frank, is not even so much the idea of, let's say, in a criminal context, a preliminary hearing, rather, what someone says and then what they say in trial, but even something as simple as what the officer has indicated in their memo book notes, and then what that officer has indicated in an actual incident report, respective of that memo book notes. What's your experience been at how you may go after some inconsistencies, or maybe you can speak a little bit about that world?
I look for a lot of reasons why. So an inconsistency between notes and an incident report could be a bad copy and paste job, where they've taken incident reports from previous cases. And it's not that they mean to do anything wrong, it's just, I don't want to say laziness, but they're trying to be efficient. Yeah. And in that, you'll find problems. And it's accepted that what they put in the incident report should be reasonably accurate. Yeah. So, we've had them as bad as wrong defendants' names in the incident report. So it's important that they're accurate in what they do, right? And note-taking is also extremely important.
Absolutely. Now that being said, as far as I'm concerned anyways, and you may have a view on this, but the incident report, if an officer, the investigating officer, has done his or her memo book notes, in essence, the incident report is basically the storytelling or narrative version of what this officer has written down in their point 4 memo book notes. The memo book notes, of course, want to be contemporaneous with the actual incident, at the time of defense, shortly thereafter. The incident report written as close to the memo book notes as possible. So what I'm curious about is, and maybe you could talk about your experience with this, whereas let's say the incident report has been written, hours or days for that matter after, the memo book notes. And for example, there's things in the incident report that would be relevant and material, let's say maybe even something such as rights to counsel that are referenced that aren't in the memo book notes. What's your sort of take with that? And maybe in the context of ensuring that the officer has everything relevant and material in their actual memo book notes.
Firstly, I don't want to be seen as advocating for, sloppy police work, but notes are generally done contemporaneously with the investigation and they're done at the time. And so it's when it's freshest in the officer's mind. When they're doing a report several days later, they may confuse this case with another case, and so you might find stuff that he honestly remembers doing but didn't do. A devastating answer I got once was, well, where the incident report differs with my notes are more accurate because it was the freshest in my mind. And that, from my perspective, really hurt because he was honest.
Gotcha.
So, but you want to avoid the inconsistencies because, sloppy one place might mean sloppy somewhere else.
Yeah.
So that, use your notes when you're doing the incident report and you'll fare a lot better.
Interesting. And still, Frank, on the topic of memo book notes, is it fair to say that anything that would be considered, relevant and material, an intricate part of that specific matter that now we find ourselves in court should be in the memo book notes? And on the same topic, what really is the leeway, or how much can an officer speak to that would be in that realm of relevant and material that would not be in the
It should always be in there, even if they remember it, because the problem is sometimes police officers don't consider that the prosecution has a duty to disclose their case. And when the disclosure is missing elements of the offense or salient pieces of evidence, if the first time you get it is in the trial, it could be an argument that it's trial by ambush. So that only heightens the importance of notes.
Gotcha. And still on the topic, just to maybe take it one step back, again, we talked about a time frame that could exist between memo book notes and an incident report, or maybe even taking witness statements for that matter. How important is it for the officer to be able to speak to those time frames? Because I would imagine you as a defense, holes in time are something that you may try to go after as far as credibility issues, right?
Yeah.
So it's what would be your sort of experience with that as far as going after holes in times? What would
I will go after every single hole and every single time problem I have.
Yeah.
And it's important that evidence be tested because in our system it's important that we make sure that someone committed an offense.
Yeah.
And that's the only way to make sure that they've committed the offense is by testing that evidence.
Absolutely. And I did mention briefly the idea of credibility. So, in the defense world, how much of a role does it play to try to attack the credibility of the officer? And what are some of the ways that maybe an officer watching this could try to be aware of maybe these types of things?
One of the things I do is I search the legal databases for cases where they've made adverse credibility findings against police officers.
Okay.
Online databases are becoming more and more available,
Yeah.
and so if I find 3 cases where an officer wasn't believed, I will smell a rat and find a problem, and I will put these to the officer. So it's important that, if you're caught in a fib, just own up to the fib, because it'll make your job later a lot. And police officers don't mean to lie. The biggest confusion is where we confuse credibility with reliability.
Yep.
And a lot of times you have someone testifying to something that they absolutely believe to be true. It just isn't. But it doesn't mean they're lying. It means they're wrong. I don't care if they're lying or they're wrong, I just want it to be in my favor. But it's important, though, when they're giving the evidence, that they remember that what they say is important, and it only enhances why, it all begins with their investigation. Begin with the end in mind, because when you're going to charge someone, think to yourself, how is this going to play out in the end? So that's why you write good notes, because you don't want to have to answer questions, why you remember something, why didn't you write it down? You know that your notes are important. Why didn't you put this down? This is like an important piece of, you say you cautioned the guy, you didn't write that down. How do we know you cautioned him? Don't ever put your credibility in jeopardy by not writing it down.
Of course.
And
still on the topic, I can think of one example from my defense practitioner days. I believe I did that for a short amount of time. However, there would be a choice select few of officers, to take it down to basics, for example, in speeding matters. So someone's charged with speeding, you're going through the notes, and then, they talk about testing the radar, this, that, and the other. But sure enough, definitively the radar they're using, it's omnidirectional. They didn't make any notation to the idea that they set this radar specifically to monitor a specific direction to travel. And arguably, that's obviously something that's very relevant material, especially depending on the time of day, the traffic coming in different directions and things of this nature. And I'm sure you probably had that once or twice in your career.
A few hundred times.
Yeah, or a few hundred times for that matter. But that being said, and we were just talking about the idea of credibility with the officer. Now, there's something to be said for an officer who commences a proceeding, gets on the stand, and maybe almost paints a picture like maybe they didn't do the most diligent job, maybe it wasn't a good charge, so to speak. And what my experience would be, and I'm curious to get your take on this, is, as a defense, you're asking, leading questions in a manner, of course, that's indicative to get the answer you want. How often is it that you come across an officer who, for example, a question warrants a simple yes or no, but this officer is being argumentative, they're giving you answers indicative of getting personally attached to the charge and not just being true to the proceeding?
We see that all the time, actually. The best officers never get personally attached and just answer yes or no. As soon as you ask a question, a yes or no question where you don't get a yes or no answer, you almost always know you got them, right?
Yep.
You know that they're trying to fight you back, right? And especially if it's an obvious yes or no. Did you do this? Well, I don't have to do that. Like, I didn't ask if you had to. I asked if you didn't. And so almost always I know that if they don't answer yes or no, a lot of times we ask a yes or no question just to see if there's...
Sure. And would it be fair to say that, if you were to ask a question that warrants a simple yes or no, and the answer gives you that simple yes or no, even thinking that it may look damning, does this put a bit of a button in your...
It gives the appearance he's got nothing to hide. People make mistakes. People are human. You know what? There's nothing wrong with saying, okay, you know what? I'm sure of myself, and maybe I didn't follow best practices, which I'll remember for next time. But yeah,
absolutely. There you go. Right from the
and
master
more
himself.
Importantly, from a long-term standpoint, that justice is going to remember you being honest and you saying, "Oops, I made a mistake," and then the next time when you didn't make that mistake, they're going to believe you, right? Long-term, follow the knife, and just be honest.
All right. So Frank, I guess what I'm wondering is, would you say, you being a defense practitioner, that there's maybe any recommended way for any officer watching really anywhere in the globe right now, if there's any recommended way that they should best present their evidence showing up in court when it's time for examination in chief, when they take the stand, how they may want to go about it, speaking to, let's say, even a format for that matter, how they may want to go about it, that, and again, not to make your job more difficult moving forward, but that may make it a little bit more difficult for the defense to try to attack the evidence.
They can make my job more difficult. I'm all about raising the bar in the profession from all sides of the fence.
That's why we brought them here, folks. All right.
Give evidence, if given in a chronological, straightforward way, is always good because it makes it easier for everyone to follow it. I don't have to cross-examine as long. Don't give too many details because then it makes my job easier in cross. Don't give minimal amount of details because I'm going to keep you in the stand a long time for cross. For provincial offenses court, the best advice I could give is that think of your provincial offenses cases as training for criminal cases. And I had someone many years ago who I'd given a real hard time to, and it's an adversarial process and nothing personal, just a job. But years later, he saw me at Old City Hall and he says, "You know what? I thought about you and I was getting grilled by some lawyer in criminal court and I felt like you got me ready." And I was like, the best compliment I could have ever had.
Absolutely.
And so, it's important to remember that the person giving you a hard time isn't wanting to. It's just a job. I never complained about an officer charging someone, so don't complain about me testing the evidence is the best way to look at it. But and qualify your evidence as you go because you want to make the prosecutor's job easy. The easiest prosecutions are when you ask an officer to give their evidence and you don't have, as a prosecutor, don't have to ask them any questions.
Absolutely.
Right?
Yeah.
So, and I always say, if you really want to do a good job as a police officer, prep the case for the guilty plea. Just build your case enough that it's ultimately going to likely result in a guilty plea.
Absolutely. And even still sort of on the same topic of the provincial offenses court, it goes without saying that the learned justice of the peace, the trier of fact in the provincial offenses court, they obviously hear matters under just a ridiculous amount of different provincial legislation. I myself, when I was prosecuting Government of Ontario Transit, I'd be on the same docket as about 8 different agencies. 7 of them I've never heard of them before in my life. So the reason I bring this up, there's something to be said about the officer taking the stand and making assumptions. And of course, there's the saying, when you assume, you make an ass out of you and me, so to speak. And why I bring this up is because, it may be that this justice of the peace has never dealt with your business before, so to speak, or your legislation. So there may be certain, pieces of evidence you bring or acronyms. For example, for transit enforcement officer, they talk about handheld fare card reader devices. And I can speak to myself being in Barrie Court.
I have no idea what that is.
Well, there you go. And I can speak definitively to that of being in the Barrie Court. The Justice of the Peace had never dealt with our matters before. And, you can't assume that this person knows what this device is, how it works, how you would know it was working at the time, how it was set specifically, indicative of this incident. So these are things as well as the officer goes through it. If there's any part of the evidence, and I don't know what your experience has been with that, or even speaking perhaps to the radar device in traffic court, if it comes to that part about talking about this device, for example, that would form an integral part of the evidence. What has your experience been with the officer maybe overlooking that and not getting specific about this piece of evidence?
It makes the case disjointed because invariably they're interrupted and they're asked, what does that mean? Yeah. If you're using specialized vernacular, try to avoid acronyms, spell everything out. If you're doing something and there's a piece of statute that says you can, explain, pursuant to the section, this particular act, this particular section, I did the following. And because some statutes provide for things that others don't. Yeah. And it might be justified what they're doing, but we don't know that. The justice, I may know it, but the justice probably would, especially if it's something that's not prosecuted all the time.
Absolutely, makes sense. And one last thing that I want to talk about, and I bring this up because this is something I've dealt with firsthand as well. The idea of the officer, commencing a proceeding, we're in court now, and the idea of the officer talking about the defendant's past behavior on becoming or prior instances that would not be respective of, this specific incident that finds us in court. I mean, how many derailments have you had in this sort of regard?
Well, just because they did it before didn't mean they did it this time. So the records are they're presumptively not admissible in the trial proper. They're very relevant on sentencing because if you're going to deter someone, you want to know their prior history. But for the trial, you generally don't get a record of it.
Exactly. So as far as an officer, even wanting to talk about the fact that this guy or girl, for that matter, did something bad on a prior date, of course, if for example the defendant takes a stand and opens up that world and talks about prior things, of course it's sort of fair game. But obviously the officer can't.
And you have to. The test is the prejudicial effect can outweigh its probative value, and so there are sometimes you have what I call your jerk defendants who they're giving the finger, they're doing things that make them unlikable. And, police try to get that in. Yeah. Stop trying to get that in. He's being prosecuted for the red light or the speeding, not his rudeness, right? And similarly for officers, I see a lot of defendants get in the witness box and talk about how much of a jerk the officer was. But, again, that's not relevant, And most importantly, police officers, they're at risk. They face a lot of dangers. They don't know the person they're approaching. And it might have been a situation where their, personality's heightened, I guess. And so both sides shouldn't be faulted for it. Defendant's having a bad day and he gives a guy a finger. Well, it's nothing to do with the charge itself. Just try to avoid putting that stuff in evidence.
Gotcha, makes perfect sense. Well, I'll tell you what, Frank, this has been a wealth of information. I'm sure there's a lot of people watching right now who are so very thankful for you joining us here today. So this has been On the Stand with me, Brian Lash, joined by the one and only Mr. Frank Alfano. Of course, as always, I appreciate all the views, all the likes, all the commentary, and I look forward to seeing you in the next episode. For now, have yourself a great day. Take care.